David, thank you very much for joining me this evening in Hong Kong from the East Coast of the US, your morning time. You are, of course, the newly appointed co-chair of HKIAC, along with Rimsky Yun, SC. And you've both just taken over from Matthew Gehring. So welcome on board.
To be doing so. Thank you, Sarah. Thanks for taking the time to do this. But I'm looking forward to my term as HKIAC co-chair.
Wonderful. You are, of course, a global leader in international arbitration, and you are very well known around the world. You've practiced for more than 35 years in private and public international law, counsel, arbitrator, thought leader, and you've been with Debevoise & Plimpton for 31 years as a partner and a bit longer as well with the firm in total. And the purpose of this interview really is for listeners to hear more about you and your career and this new step in your career as co-chair of HKIAC.
Great.
So I thought it would be good to start at the beginning with, when we talk to people like yourself with such amazing careers, it's always interesting, I think, to go back to the beginning and ask, how did it all start for you? Was your family a great influence? How did you get into international arbitration from the beginning?
Sure. So I grew up in New York City, right in the middle of Manhattan. Both of my parents came from the Midwest, but had ultimately moved to New York to begin their professional careers. Both were very involved in international affairs. My dad was a lawyer who had a lot of international clients. My mom did a lot of volunteer work, including at the United Nations, and had a master's in international relations. So I always grew up with a big focus on international issues as well as and global politics. And I saw from my dad how exciting a career as a lawyer could be, how a lawyer really greases the wheels of business, of public policy. A lawyer is deeply involved in all of those activities. So I was excited early on about becoming a lawyer. But I also wanted to do litigation because I thought being able to both resolve disputes was one way of being helpful to society, but also it's a great way of influencing public policy. I was a child of the 60s after all. And so, when you combine the interest in litigation with the interest in international affairs, international arbitration seemed like a very appropriate way of blending them.
A lot of people, when they get into international arbitration, it's a bit of a mix. It's direction, but it's also because they were in the right time at the right place. For you, how did you first get into international arbitration?
I was fortunate to be in the right place. I joined Debevoise, as you mentioned, in the beginning of 1982, and after a judicial clerkship. And Debevoise already had some reputation in the field of international arbitration. There wasn't really a practice that people thought of as international arbitration in those days. But in the 1970s, Debevoise and our senior partner then, Bob von Meeren, had won the Topco versus Libya case, one of the 3 Libyan oil nationalization cases, and had won the best result of the 3. So it had already created some reputation for the firm and Bob. And then talk about being in the right place at the right time. Literally my first day at the firm, a new international arbitration came into Bob, and he knew that I had an interest in the field, and he pulled me out of our orientation and asked me to work on it. I began working on international arbitration right from the start. And by the way, it was an Asian-focused international arbitration.
Oh, really?
It was a claim by a smaller US oil company against Indonesia involving tax issues. So I've been involved in international arbitration in Asia literally from my first day as a lawyer.
Okay. So what was it like back then? It was in the 1980s you started out in international arbitration. What was it like when you look back over all of these years? How does it compare to now, and what was it like in the 1980s in international arbitration?
Yeah, well, in the 1980s, again, people didn't think of international arbitration as a separate field, and we at Debevoise had more international arbitration than probably most firms in those days. But even we would have, you know, one or two cases going on, and then they'd finish, and then you'd have to wait for a little while for another one to come on. So I did other litigation, you know, as well. But some of the cases were really quite major. Two that come to mind. One in the mid 1980s, and particularly in this day of the coronavirus pandemic and a lot of claims of force majeure. I think that this might be interesting. We acted for a U.S. energy company that had a long-term LNG contract with Sonatrach, and it was signed in the 1970s in the midst of the energy shortages. But by the time they built all the facilities, and again, LNG was a fairly new technology in those days. By the time they built all the facilities, got all the government approvals and everything, it was 1983 or 84 by the time they were actually able to begin performing. By then there was an energy glut, and our client literally had nowhere to sell its LNG once it was, and they were running out of storage room at the facility. So we declared economic force majeure, which wouldn't really work so well under US law and most European laws, but the contract was governed by Algerian law. Article 1 says that, of the Algerian Civil Code, said that its terms shall be interpreted according to the principles of Islamic law, and Islamic law has a much broader doctrine of excuse. So we built out a case both on the factual side about how the energy market had changed in the 10 years, but on the legal side about the Islamic law doctrine of excuse. And one of our experts was an Iranian Ayatollah who spent half of his year in Qum with the other 99 Ayatollahs and half of his year teaching at Princeton. And so it couldn't have been a more interesting case. And we built a strong enough case both on the facts and the law that we were able to settle it quite comfortably.
Yeah, fantastic. And yeah, some resonances to today as well, isn't there? There's some strong resonances, yeah.
Absolutely, and I've certainly over the years had many other cases involving force majeure and frustration, and interestingly, a decent number of cases involving Islamic law or the Arabian civil codes. But the other case I've mentioned too, again, because it's Asia focused, is in the late 1980s, we acted for a building contractor in Singapore called Builders Federal. And we brought a claim under the construction contract. It was seated in Singapore. And shortly before the first procedural hearing with the arbitrator, we were served with an order that we could not participate because we were not members of the Singapore bar. We were not locally licensed. And so we scrambled to find a Singapore lawyer who would come to the hearing with us and would effectively act as our mouthpiece. That decision, that injunction was upheld in the Singapore courts.
Okay.
Interestingly, the junior on the other side of that case was Sundaresh Menon. So he and I often joke about being on the opposite side of that matter. And it ended up not only setting Singapore back as an arbitration center for a while until they changed their law, but I know that Hong Kong, I think under the leadership of Neil Kaplan, in fact, very quickly amended its law to make clear that the Hong Kong licensing requirement didn't apply in arbitration. So it helped build Hong Kong as an arbitration center through the 90s as well. Yeah,
no, very important change. And I think reflects somewhat how Hong Kong is quite a liberal jurisdiction in terms of representation in arbitration, both in proceedings and arbitration, but also before the Hong Kong courts, in terms of not requiring Hong Kong qualified lawyers necessarily to be before the courts.
Absolutely. And of course, one of the reasons why people choose arbitration is to have counsel of their choice, not to be focused on local procedural requirements. And so it was important. I think that the Builders Federal received a lot of publicity really around the world, and I think helped emphasize that as other countries sought to build their own arbitration laws.
Right. Yeah. So I've obviously looked over your CV very carefully, and I'm really struck by the breadth of types of cases that you've done in your career. And I wanted to talk about, I wanted to invite you to speak about some of the special cases in your career across different areas. So, for example, public international law, investment treaty arbitration, international commercial arbitration, and I also know that you have quite extensive experience in sports arbitration. So perhaps we could start with public international law cases. And I know that Debevoise and Plimpton is currently has a case before the ICJ brought by Qatar against the UAE and some other Middle Eastern states under the Convention for the Elimination of Racial Discrimination. So can you talk a little bit about that case, and then any other interstate arbitrations that you've been involved in that were particularly remarkable?
Sure. Well, yes, the Qatar case is a wonderful example of how public international law can be used to help resolve disputes between states. Now, of course, the dispute between Qatar and the 4 states that have imposed coercive measures on it since June 2017 continues, but we hope that through the various pressure points that we've put on, it will eventually lead to a resolution of the problem. Right. As you mentioned, we brought claims against the UAE under the Convention on the Elimination of Racial Discrimination because of the expulsion of Qataris from the UAE in June of 2017, which violates the convention. We won provisional measures by the ICJ against the UAE to reverse some of those measures. We've brought proceedings in the UN Commission, CERD Commission, on the same basis. We also have proceedings in front of the International Civil Aeronautics Organization, relating to the ban of Qatar Airways to overfly those 4 countries, right? And some investment treaty claims based on those same matters. So one of the things that's so fascinating about that work is just the intersection of public international law, private international law, investment treaty protection, private claims. It's all in a very interesting geopolitical context.
Yeah, and in terms of just picking up on your investment treaty work, I mean, you've done so many cases as counsel, as arbitrator. Are there any particular cases that stand out for you over the course of your career?
I think a few in the investment treaty area. I guess I would mention the Occidental case that we won against Ecuador. Yeah. At the time, it was the largest award in an investment treaty claim. Originally more than $2 billion, that then got reduced a bit on annulment. But it was still, I think, the largest even when it was reduced. And one of the things that was interesting about that case was, again, we worked very hard to make the arbitrators comfortable in awarding such sizable damages. And we did so by focusing on the actual economic and financial projections that the parties made, both Oxy when it was operating the field and then Petroecuador after they seized it, so that the tribunal could be comfortable that these were not projections by experts, but rather what business people were actually doing in running the business. We also used a technique which we have now used a few times since, and which I know some others have picked up on, which is that we asked the tribunal to let the experts know, once they had determined what the inputs into the DCF should be, and have the experts then jointly calculate, run the model, which gave the tribunal comfort that they were getting the number right. Unfortunately, I think too many arbitrators don't have comfort with the numbers or how these models work, and they may increase one element a little bit and decrease another one a little bit, and then kind of guess how that impacts the model. But we wanted to, in order to get them to be comfortable with such a big number, have the model actually run. And so they used that, and they just used the number that was jointly run by the experts. And we've used that same technique in the Hydro versus Albania case that we won last year.
I think that's really interesting because you know, a lot of tribunals aren't comfortable when it comes to the quantification of damages, and there's a lot more scope for using experts, tribunal experts or experts appointed by the parties in a way that is much more closely managed by the tribunal to use their expertise, which perhaps the tribunal members don't have themselves. So, and I think that's one of the areas that's been picked up on in the ICA-ASIL task force on damages. That's co-chaired by Catherine Amirfar, of course, a partner of yours, and Gabrielle Naturbas. And they're doing some really interesting work in terms of finding ways to make tribunals' quantification findings more robust, more thorough, both in terms of legal issues, procedural issues, and also the actual quantification. So it's interesting to look at the more creative or more flexible use of experts.
I agree with that, and Sarah, I know you're part of that task force too.
Yep.
So thank you for your contribution to it. But I know Catherine is finding it very satisfying to co-chair it. But it is important. I know from parties' perspective, it can be very frustrating to have, to get a very long award that half of which is just repeating the procedural history and the arguments which the parties already know.
Absolutely.
And then there's discussion about the liability issues, and then you have about 5 pages on damages. Because they want to make sure, because that of course is such an important element of any ultimate decision. So
absolutely,
getting tribunals comfortable with it in a number of different ways is important going forward.
Yeah.
I guess I mentioned the Hydro case a minute ago too, and I could mention that just because of the provisional measures we were able to win there. It was actually one of a series of cases we handled. We had a number of investment treaty cases where the government on the other side was threatening to, or did bring criminal proceedings against our client, the investor.
Right.
And we were able in the Hydro case and in some others to convince the tribunal to use their inherent power to protect the integrity of the proceeding, to enjoin the state from proceeding with its criminal proceedings, at least while the arbitration was going forward.
Right.
And we had a very good panel in that case as well, and it and so it went forward. It protected our client while we were able to take the case to its conclusion.
And I noticed that in that case there were also extradition proceedings involved, and part of the provisional measures was for the state, Republic of Albania, to do everything in to do all that was necessary to suspend the extradition proceedings. That's well. Right. And I think it was the first of that kind.
It was the first one that focused specifically on the extradition proceedings.
Yeah. So quite notable findings there by a robust tribunal.
I must say that case is in the annulment phase now. We're confident it will be upheld, but I have to say that the political pressure on our client hasn't abated from Albania, so we're still fighting it.
Okay. Yeah. So in terms of international commercial arbitrations, you've mentioned some of the ones that started at the beginning of your career in your Singaporean case. Have you had any others that were perhaps Asian related over the course of your career that stand out? I know that you had a very big ICC case. I think it was you got an award, one of the biggest ICC awards ever. It's the Hyundai Heavy Industries case.
Correct.
Can you talk a bit about that? Or?
Sure, I was going to mention that. I've had many commercial arbitrations based in Asia, based at the HKIAC, in fact, over the years. But the Hyundai Heavy Industries case was an important one. We acted for the minority owners in a joint venture who felt that their rights had been breached by the majority owner, which is a Middle Eastern government-owned company. And we were able to prove the breach, but also prove that the breach was material. And the tribunal, by the way, had two Hong Kong legends on it. Neil Kaplan and Michael Moser were two of the three arbitrators.
Okay.
And we were very pleased that they were willing to enforce the provision of the contract that said if there is a material breach, then the breaching party must put its shares to the non-breaching party at a substantially discounted cost. And so the value of that put was about $750 million for our client, which was then perhaps the largest ICC award at the time. And if you had measured damages in some other way, it probably would have been less, but it was important, as the tribunal recognized, to accept the remedy that the parties had agreed on, not knowing which of them would be the breaching party. If breach ever occurred, parties, they put that in specifically to try to avoid the problems that did arise. To prevent a party from taking steps that would breach. So they did enforce it, and it was an excellent result. I've done a good number of cases for Korean clients over the years, and many of them have been based in Hong Kong.
Yeah. Yeah, no, we do see a lot of Korean parties in our cases, and we of course have an office there, so it's a very important jurisdiction, and it's there have been some really exciting developments in Korea in terms of international arbitration over the last few years. So it's, yeah.
Absolutely. We've also acted for the Korean government in a couple of investor state cases as well.
Right.
Talk of a decent number of ISDS cases.
Yeah.
Honored to act for the government in a few of those. And that's one of the things I've really enjoyed about our investor state practice, and my part of the firm's practice in that is that we both act for states and investors, which helps whichever side of that dispute you're representing in any particular matter. Having acted for both, I think really helps give you the perspective of what how the other side is approaching it.
And exactly. Yeah, very
in a better way.
Yeah. And speaking of investment treaty cases, the first investment treaty case that HKIC administered was one involving the Korean government under the US-Korean treaty. That was a much smaller case than some of the others that it's facing, but they were successful on that, and that's public. So, and what was interesting in that case is that it was also seated in Seoul. We have another case that we're running at the moment, which is seated in Hong Kong. So, okay, so let's take a little bit of another direction and talk about some of your sports arbitration experience, because that looks really interesting. And I noticed that you are, well, you're currently the Deputy President of the Anti-Doping Division of the International Council of Arbitration for Sport. And you were, for many years, over 20 years, you were a member of its panel of arbitrators, so you sat in many cases. And you also have been an arbitrator at the Beijing Summer Olympics, the Athens Summer Olympics, and the Salt Lake City Winter Olympics.
For a lawyer who's a sports fan, it's a wonderful combination of things coming together. So
yes. Living the dream.
Yeah, absolutely fascinating work, and obviously has its benefits too.
Yeah, and so free tickets, right?
When you're an arbitrator at the Olympics, you get credentials that are similar to the IOC members' credentials. So yes, so you can go into any event.
Oh, very good.
We do keep busy, but when we're not sitting as an arbitrator there, yes, we're able to go to a good number of events. So it's
okay, but you can't participate in the events. Just watch.
Nobody would want to watch.
So can you tell us about some of the cases that you saw over your time, perhaps in the anti-doping field? Did you have some interesting cases there?
I did. I'll mention a couple. I sat on a series. People may remember the cycling had a large number of doping issues.
Yeah.
And I sat on the Floyd Landis and Tyler Hamilton cases where they were both found guilty of doping and suspended. And they were both part of the Lance Armstrong team. And so when Lance Armstrong and his team were ultimately charged, then Landis and Hamilton were cooperating with USADA, the anti-doping agency in the US, and provided evidence to support the claims. So Armstrong didn't appeal his ban, but the other members of his team did, and I was sitting on their panel. And when Landis and Hamilton came to testify, of course, they began by being sworn. And then I immediately reminded them that they asked them if they remembered my sitting on their panel, and they said yes. And I said, do you remember you gave exactly the same oath before you swore under oath that you were not guilty of doping?
Right.
And now you are testifying that you were and that others on this team were. So why should I trust your testimony now? And they both gave answers about, well, they've seen the light and they were just trying to support the team, et cetera, et cetera. But I felt, and my co-arbitrators felt, that it was very important that when we did uphold the bans, we very specifically didn't rely on either of their testimony because they were admitted perjurers, and
Right.
we thought it wasn't necessary. The excuses for doping that athletes came up with were, are fascinating. In Tyler Hamilton's case, he was guilty of blood doping, and he claimed that the fact that he had two completely opposite markers of various elements in his blood, which is impossible, came from what he called a vanishing twin, that his mother had had a twin embryo that never developed, but had somehow infiltrated his blood. And he actually, so we rejected that pretty easily. But the doping cases have led to some very interesting work. But I also had the honor of sitting on Oscar Pistorius's case. If you remember, before the London Olympics, he was banned by the Track and Field Federation on the basis that the blades that he ran on provided him with an advantage under.
Right.
And we had a lot of scientific evidence, and in fact used a technique very common in international arbitration of having the experts sit down and write down what they agreed on and what they disagreed on. And it turned out that they agreed on many of the points that supported Pistorius's claim that it did not provide him with an advantage.
Mm-hmm.
So we so ruled, and which allowed him to participate in the London Olympics.
Okay.
So it was, of course, what happened to him after that was a terrible tragedy, but we were very pleased that we were able to allow him to compete.
Right. Did you meet him in that process?
Yes, and he was a very, given what happened afterwards, I found it particularly shocking. He was seemed very smart, very respectful, very down to earth. And that's one of the things that's been fun about doing the sports arbitration too, is that these aren't claims by one company against another for hundreds of millions of dollars, but these are individuals, and you take it very seriously. I've sat on a number of cases in the United States where one athlete challenged the other's selection to go to the Olympics. And so I had to decide if the rules had been properly followed in selecting that athlete. And in some cases I found that they hadn't. And so I ruled that a different athlete had to go, or I defended or affirmed the decision. But one way or another, it was, I knew it was somebody's career they'd been working on for their whole time, and I obviously take very seriously sitting as an arbitrator in very large commercial cases. I have to say I'd probably lose more sleep over the decisions involving individuals. Yeah,
I mean, it can be a heartbreaking decision for someone, can't it?
Absolutely.
To have their one shot at the big title tonight.
Absolutely. there was one story I like to tell is about one American mountain biker who I ruled in her favor after the U.S. Mountain Biking Federation had literally changed the qualification rules after the time period had ended, so that she had not been allowed to, so that somebody else had been selected. And I ruled that if they had made that change during a time when the athletes could have done something about it, that would have been fine, but they can't change. It's like changing a score in a football match after the match had already ended. So I ruled that she had to go. So I went to watch the mountain bike competition in Athens and met her afterwards. And she kind of stepped back and then gave me a big hug and thanked me. She hadn't medaled, but she had enjoyed the experience. And I've won some big cases for a lot of clients. I don't think I've ever gotten a hug from the general counsel or the CEO. It just showed how much it means to these individual athletes.
And I'm sure it was a big sweaty hug as well, if it was just after the race.
Absolutely. 3 hours mountain biking in the Athens sun. It was,
sweat, everything.
It was a mixed blessing.
Yeah. Oh, that's wonderful. So, and then I think, another really notable pinnacle in your career was, of course, that you were elected president of the IBA, 2015 to 2016. And you were the first American elected into that position in 25 years. Mm-hmm. And so you were in there, you had previous positions within the IBA, some very high-ranking positions, and you'd been working within the IBA structure for a long time. But can you tell me about that year and what you felt you achieved in that role and how the experience was in that role for a year?
Sure. It was actually a 2-year term as president, so which was good because it takes a long time to get some of these projects up and running and then through fruition. So I was really honored to do it. I'd say I'll mention a few of the projects that we implemented that I either started or was able to take to fruition. But I began a project on judicial corruption. We called it the Judicial Integrity Initiative, and it focused on what were the root causes of judicial corruption. We conducted a survey of lawyers around the world, which found far more concern about corruption and political influence in judicial decision-making than we expected. And we implemented a number of projects that have been used in a number of countries to reduce corruption. So I was very pleased with that. And the IBA, in fact, is continuing work on the Judicial Integrity Initiative, and I'm continuing to do some work with them on with the UNODC and other organizations that are doing that. Another anti-corruption project that I led was a task force on human trafficking, which produced a report on the impact of judicial corruption on human trafficking, and effectively showed that without corruption by police, by immigration officers, by judicial members, and others, human trafficking couldn't occur, that it was really at the root cause of it. And it was really the first report that pulled all these strands together in a way that made a difference. During my second year as president, the Pope had a conference on human trafficking at the Vatican. And I was invited to be one of the 100 or so participants. And so it was wonderful. And I got to have my 30-second greeting with the Pope.
Oh, really? How did that play out? Did you have to kiss his hand, or?
No, it was actually it was a little more informal than that. He came and gave a wonderful speech about the law and what the law means and justice, and put it all in the context of human trafficking. And then he kind of walked through the audience a little bit, and some people got to shake his hand or greet him, and then he went outside and stood around, and frankly it was a little bit of a scrum, because he just kind of stood in the middle, and people would kind of work their way through to be able to say a quick hello and thank you. So I did so without knocking anybody down, I promise.
Oh, good.
But it was wonderful that it meant so much to him. But also, while IBA president, I helped complete a project the IBA had been working on business and human rights, which was designed to explain to lawyers around the world how the UN guiding principles on business and human rights, the so-called Ruggie principles, impact their clients and impact us as lawyers, and the obligations we have to make sure that our clients are not causing human rights concerns through the work that they do. And that has had some wonderful influence. I was also very pleased that during my 2 years, one of them was 2015, which was the 800th anniversary of the Magna Carta.
Oh, yeah.
And so I was able to participate in a number of the celebrations in the UK, including being at Runnymede Field on June 15, 2015, which is 800 years to the day, which as a historical buff as I am, was really very meaningful. But we also used it as an opportunity to talk about the importance of the rule of law. And we had Magna Carta focused conferences in New Delhi, in Cape Town, and in Rio de Janeiro, all focused on using the Magna Carta's anniversary to, again, just talk about its continued relevance and the importance of the rule of law. And finally, we did a lot of work. I started and continued work in the IBA on climate change and the role that lawyers have to play in mitigating climate change. And we put out a very big report while I was vice president. We created a couple of task forces, and I made sure that committees were focused on climate change issues during my time as presidency, and that work continues as well. So it was a very broad remit, and I was very happy to be able to have some influence on public international law, the rule of law, during those 2 years.
Yeah, fantastic. I remember the report. I was at the PCA at the time, and we were consulted on with respect to some of the relevant cases that the PCA was running or had run in the past with respect to climate-related issues. So, very impressive piece of work.
Exactly, and one of the areas we have focused on is just how arbitration and dispute resolution can be used to help further the mitigation process.
Yeah. Wonderful. Well, we've done a bit of a tour of the world. So let me bring it back to Hong Kong. I think you first visited Hong Kong in the 1980s.
That's right. My first visit to Hong Kong was in 1981. My wife and I were married in September of 1981, which is the end of my judicial clerkship and before I started at Debevoise. And we took a 3.5-month honeymoon all through Asia. We had been to Europe a few times. We thought Asia was so far away, we probably wouldn't have many opportunities to go back. Who knew then that my career would be focused on Asia? So we traveled around Asia for 3.5 months, and including a couple of visits to Hong Kong during that time. And so I love my trips to Hong Kong now, and just being able to experience how much it has changed. Of course, the harbor was about twice as wide in those days. There were still junks, not just for tourists, but actually working fishing boats going all through the harbor.
Did you go to mainland China?
We did go to mainland China. This was only a few years after it had opened to
of course.
tourists. So the only way we could go in was as part of an official tour. So when we arrived in Hong Kong the first time, we went to the China Travel Office, the government office, and asked what was leaving in the next few days. And we were able to get onto a tour that took us to Beijing, Shanghai, Xi'an. The terracotta soldiers had only just been uncovered. So it was great. Smaller city called Luoyang, and Guangzhou. So, but again, mainland China was entirely different.
Yeah.
And there were no cars. Everyone was on bicycles. Everyone was wearing their Mao jackets. When we flew into Beijing the first night, there were no lights. I mean, the airport was dark. The
Wow.
drive from the airport was dark. There was very little electricity. I know we have our slides from that trip, and often before friends or family are going to China now for the first time, we insist that we show them the slides, because we say you can't really understand China today unless you understand just how much it has changed in just a generation.
Yeah, that's really incredible. I mean, to imagine landing in Beijing and there not being lights in an airport. I mean, all my trips to China have included arriving at some of the most magnificent airports you'll ever see.
Right. No, and I'm so happy that we had that experience, really getting to understand Asia. For the 3 months, we'd spend a week to 2 weeks in each of the countries that we visited, and we're traveling. We were young, we were traveling very light, and got to just meet a lot of people, and to see the development in Asia over that generation. How much has changed in so many countries has, I think, helped. Well, it certainly helped me as a person, but it's also, I think, helped me in working for clients in Asia, and in matters involving Asia, because it's just helped understand where the region has come from in a very short time.
Absolutely, yeah. So I know you've been to Hong Kong many times since then, and I know that you were in Hong Kong in 2018. You came down for Hong Kong Arbitration Week, and before that you were here in 2015, and I know that you gave a keynote speech at the ADR in Asia conference, which is the flagship event of the Hong Kong Arbitration Week that HKIC puts on. And I've read a copy of your keynote speech, and you really focused in that speech on the new contract between arbitrators and parties, and it seemed to be a bit of a call for arbitrators to perhaps pull their socks up a bit. And there were 5 main points that you made. First of all, that arbitrators should be truly well versed in the factual record of a case and the relevant legal provisions. That secondly, tribunals should bring their experience to bear in proposing and applying procedures that fit the particular case before them, not just importing what they used in the last case. Thirdly, to make sure that they have an ongoing knowledge of the case, so to keep abreast of the issues of the case so that they are ready to decide procedural issues as and when they arise, rather than waiting to study the case just before the hearing, for example. Fourthly, to conduct the hearing attentively, not to be distracted, to eliminate distractions. And fifthly, very importantly, to issue the award in a timely way and to schedule in proactively time to deliberate and time to draft, just as you would schedule in time to sit at the hearing. Do you think that arbitrator diligence has improved since your speech, since that time?
I think arbitrators have become more conscious of their obligations to the parties, in structuring cases in a way that makes that it meets the parties' expectations. I do think that, for example, with respect to awards, we at Debevoise have had some good success in a couple of techniques that have helped move awards. We've been able to put into the initial procedural order an expected timetable for the award after the hearing, to make clear that the award should be issued in 3 to 4 or whatever the period is of months, and not just have it open-ended. We've also used a technique that we call thumbs up, thumbs down, where again, rather than, and this happened in too many investment treaty cases, where there was a separate jurisdictional phase, the tribunal would only set the schedule for the jurisdictional phase, They
Sure.
would then take far too long to issue the decision on jurisdiction and only then begin to set the schedule for the rest of the case. So it dragged it on. So both in commercial cases and in investor state cases where there is a preliminary decision on jurisdiction or something else, we've had some good success in convincing arbitrators to agree that they would give that the entire schedule is set from beginning to end of the case,
Right.
not just for that first phase.
Yeah.
And that at the end of the jurisdictional phase, they would issue a quick decision that just states there is jurisdiction, there isn't jurisdiction, or whatever the procedural issue happened to be. And then if there is jurisdiction, then the schedule just continues and they can issue their reasons for that at any point along the way. But in the meantime, the parties can start working on their merits memorials.
Right.
If there is no jurisdiction, then the case ends and they can take as long as they want to issue the award. But but it keeps the clock moving, keeps the case moving in a way.
Yeah.
So I think arbitrators have been more diligent in that way. And I think, I think one of the advantages that's going to come from this pandemic and all the virtual hearings and work that we've been doing is that we're all becoming much more comfortable with it. I know the HKIAC has done a wonderful job in holding virtual hearings and creating a virtual hearing center, and that's going to be enormously helpful to parties going forward. But I also think that it will allow parties and arbitrators to stay in touch more during the case of the proceeding, rather than just having an arbitrators kind of issue the procedural order and then say, "I'll see you at the merit." And we'll be able to have more frequent conversations just like this. It will force arbitrators to stay current and to read the papers on a current basis rather than waiting till the end. And I think that will be very good for the process as a whole.
Absolutely. And I think it will also have a great impact in terms of availability of arbitrators, where rather than try and find a block of 10 days for 3 very busy arbitrators to sit all at once, then hearings can be scheduled and around a certain period, and it doesn't have to be such a block and people don't have to travel. So there's a lot more flexibility. Maybe it won't be something that parties want for all hearings, but I think that there are quite a number of types of hearings that can be run virtually, and it works very well. And that's certainly what we've seen. Yeah, even with large merits hearings, construction cases, 10 days long, we've been able to manage that, involving multiple jurisdictions, multiple countries, multiple time zones. I think the time zones is perhaps one of the tough parts, but not insurmountable. Yeah.
No, and even the merits hearings raise their own challenges, but I think we can have a lot more interim hearings and decide some issues along the way that will help smooth the process. So I'm looking forward to both as counsel and as arbitrator to using that flexibility and to working with you and others at HKIAC and finding ways we can encourage the parties using HKIAC to do just that.
Yeah. Now you're co-chair of HKIAC. We're very happy about that. We're very proud of that. But you've done a lot of work with a lot of different institutions, American Arbitration Association, LCIA, Stockholm Chamber of Commerce, ICC Commission on Arbitration, and SEAC, and then a number of other institutions. And I guess just really to close, what attracted you to the role of co-chair of HKIAC, and what do you hope to achieve over your term?
I've always had a lot of respect for the HKIAC. It's been one of the world's leading institutions since its founding, and it really has played such an important role in the development of international arbitration in Asia and globally. It has always been an innovative institution that has looked for ways to enhance the process for the users, the parties. And Hong Kong itself has always been very reactive to what has been needed to make the process. We talked earlier on about making clear that parties could use whichever counsel they wish, for example, and reacting to that quickly. So, I'm very pleased to be able to continue that kind of work with you and Rimsky and others at the HKIAC. As we were just talking about, I think this is going to be another turning point for international arbitration as we work through the issues that the pandemic has caused, but also work with the benefits that the new technologies are providing to us. What I've enjoyed about my work at the other institutions is helping shape their rules, helping make them a little more innovative. And it's one of the things I've always enjoyed about the international arbitration process and practice. More generally, I think there are very few legal practices where you not only get to engage in the practice, but you also get to help shape it. You get to help create it more broadly. I mean, antitrust lawyers don't necessarily get to change the direction of antitrust law or how it's conducted, but we as arbitration practitioners through the IBA Arbitration Committee and the IBA rules, which I helped lead, or through the different institutions, we've actually been able to play a role in how parties conduct international arbitration throughout the world. And so I'm looking forward to being able to do that with the HKIAC for the next 3 years.
So I take it your father wasn't an antitrust lawyer?
No, no, a combination of commercial and disputes work. So it was, it had a very interesting international practice. Yeah.
Wonderful. Well, thank you very much, David, for your time. It's you've been co-chair now for 25 days. I think it's going very well. So,
thank you. I'm glad I haven't messed anything up yet.
No, no. But thank you very much for your time, and hope you have a good day. Thank you
very much. Thank you. Bye-bye.